Thank you, Mr. Chair, with military precision as always. Mr. Chair and committee members, thank you for inviting me to appear before you as you begin your study of Bill C-11, the Military Justice System Modernization Act. Before we begin, I want to acknowledge that the topics that will be raised in these committee proceedings are of a sensitive nature. The Sexual Misconduct Support and Resource Centre has a 24/7 hotline. If you feel the need, anybody watching or participating, dial 1-844-750-1648 for assistance at any time. I also want to thank you, sir, for arranging a special sitting of this committee to accommodate my appearance today. Members of the Canadian Armed Forces work very hard every day to defend the values of peace, freedom, and democracy, both at home and abroad. And they do it with unwavering dedication, professionalism, and resilience. We've all met with our forces across Canada and around the world, all of us. Their work has always been essential to Canada's security, but in today's unpredictable and volatile geopolitical environment, it has taken on renewed urgency. It's our responsibility to ensure they have a workplace where they feel protected, respected, and empowered to serve. That means eliminating harmful behaviors from our institution, including sexual misconduct. The
changes proposed in C-11 respond to key recommendations made in independent external reviews conducted by former Supreme Court Justices Arbour and Fish to ensure the transparency and accountability of our system and align it with Canadians' expectations.
First, Bill C-11 will remove the Canadian Armed Forces investigative and prosecutorial jurisdiction over criminal code sexual offences committed in Canada. This means that all criminal code sexual offences will be investigated and prosecuted exclusively in civilian criminal courts, addressing part of recommendation number 5 in Justice Arbour's independent external comprehensive review. Second, it will address 8 recommendations from Justice Fish's third independent review, including modifying the appointment process for the Canadian Forces Provost Marshal, the Director of Military Prosecutions, and the Director of Defence Counsel Services. Allowing non-commissioned members to be appointed as a military judge, expanding the class of persons who are eligible. Affirming the Judge Advocate General's respect for the independence of authorities in the military justice system. Expanding the class of persons who can make an interference complaint, and changing the title of the Canadian Forces Provost Marshal to the Provost Marshal General, aligning it with other senior CAF designations. Third, Bill C-11 will remove military judges from a summary hearing system and expand access to victim liaison officers under the Declaration of Victims' Rights to individuals acting on behalf of a victim. Lastly, it will amend the National Defence Act to align sex offender information and publication ban provisions with the amendments made to the Criminal Code in 2023. Together, these amendments will bring our military justice system in line with our civilian criminal justice system, ensure it better responds to the needs of survivors, and ensure confidence in our institution. These
legislative reforms are part of a broader effort to transform the culture of the Canadian Armed Forces and to make them more inclusive and representative of the people we serve. Those who do not meet these requirements will be released as soon as possible. We have also modernized dress requirements and made other improvements to attract and retain more women and ethnic minority Canadians.
We've also made progress on recommendations number 7 and number 9 of Justice Arbour's report. CAF members who experience sexual misconduct, sexual harassment, crimes of a sexual nature, or any other form of discrimination based on sex or gender while performing their duties can now bring their complaint directly to the Canadian Human Rights Commission without first exhausting internal grievance and harassment processes. We believe these are all steps in the right direction but our work is far from over. Le projet de loi C11 constitue
Bill C-11 is another crucial step towards this ideal, reinforcing our commitment to protecting Canadians, supporting survivors, and strengthening trust in the Canadian Armed Forces.
our responsibility, colleagues, to make sure our military justice system is fit for purpose. And I thank you for your part in helping us keep it modern, relevant, and responsive. I very much look forward to working with this committee as you examine the bill. I'm happy to take your questions. Thank you again for allowing me and my officials to appear today. Merci beaucoup.
Thank you, Minister. That gave you some leeway. A few extra minutes would have been fine. No, not at all. Because we're taking it away from James Bazan, our first questioner. Stan, you only have 2 minutes. Over to you. 6 minutes.
Thank you, Mr. Chair, and thank you, Minister. I just want to start off by saying that the official opposition, as Conservatives, we believe that everyone in Canada, but especially those that put on the uniform in service to Canada, should never have to deal with sexual misconduct, racism, and discrimination. And we believe that this bill is the first good step. Now that you've brought forward Bill C-11, it's been over a year since this House originally saw Bill C-66. As the new minister on this file, did you consider making any changes to the bill before retabling it?
That's a really good question. I felt, looking at the bill and getting briefed on it, Mr. Bazan, that it was the right form now to enhance trust and transparency in the system. What we did hear back and what I did insist on was getting briefings and feedback from folks, people who were applying, for example, looking to enlist, to sign up to join us. And they told us in very large numbers and in no uncertain terms, they wanted a 21st century workplace. And so they felt that this balance of measures, which we could deliver quickly and hopefully pass quickly together by all party support, I hope. The Canadian Armed Forces, I think, told us they were counting on us to get it done.
Okay. So there was some recommendations that came out of the work of this committee in the past, including November 2024, we had the Rebuilding Trust, Transparency, Accountability in D&D and CAF. That wasn't taken into consideration in the new bill that you brought forward?
I don't think the details of that but okay. Again, one of the reasons we're here is we're very open to hearing more from all members about how to improve this bill.
December 2021, even without the legislation, the Canadian Armed Forces has been moving all sexual offences that are criminal in nature over to the civilian system. Do you know how many cases have gone forward into the provincial justice system across the country?
I can't recall personally, but I know somebody at this table does, if you would.
Okay, well then we'll get to that in the second hour.
Okay.
So you don't know if there's any cases that have been delayed and that the Jordan's framework has come into play?
Not in my briefings, no. What I've been told,
Okay.
in fact, is we've made great progress with Ontario in signing an MOU on how to deal with these cases, that we continue to be in touch, close contact with all provinces, all jurisdictions, and we're very, very receptive as a two-way dialogue to make sure that we get these cases properly treated and dealt with.
Since you've been sworn in as minister, have you spoken to Justices Arbour, Fish, or Deschamps on this file?
No, I haven't spoken to them. I've interfaced with Justice Deschamps in another capacity, but in terms of following up, I intended to do so after this hearing and when I'm back from travel this week.
Okay, so in this bill, there is going to be more people appointed through order in council. That will be political appointments. Can you tell us why what's the rationale behind some being, 4 years, some are being 7 years? The ombudsman, a 5-year appointment. Why is there a difference there?
Well, I would begin by saying that the rationale for moving these appointments to a GIC appointment is because the structure and the transparency and the robustness of that process are, and we believe, superior to what exists now. It also helps make it plain that the notion of even the perception of chain of command pressures being brought to bear on these really important appointments would be overcome. And thirdly, Mr. Justice Fish wanted to align these positions with other positions in the federal government.
I think the standard is kind of like a 4 or 5 year, not a 7 year. I'm really confused on
I think
this.
the Director of Public Prosecutions has a 7-year term. So
But
I think
usually
it
people
depends.
in uniform serve about 3-4 years max in any position.
Yeah,
So
could-
now we're going 5 and 7. You know, it's one thing that we want to drill down a bit on. Now, in C11, it gives you, as the Minister of National Defense, the power to issue guidelines and directives with respect to particular prosecutions when they're used to be done by the JAG. Will that not lead to political interference potentially?
I would be hard-pressed to believe that any Minister of National Defense would want to insert themselves into a prosecution of this kind.
You were looking at Bill C11 and the department. Did you also look at other allied nations and how they have been doing this as it relates to sexual misconduct in particular? But, you know, Australia and the United Kingdom have independent prosecuting offices, the way they've handled it. You know, so have you take that in consideration?
We did.
And tried
We looked
to
at
mirror that?
comparative. Thank you. That's a good question. We looked at comparative practice. But what we really relied on was Madam Justice Arbour and Mr. Justice Fish and their wisdom and the benefit of all of their hearings and the thousands of folks they spoke to and the research papers and the analysis. And this is where they came down, and we support their views.
So why do you feel you need to have the power as Minister of National Defense to issue guidelines and prosecutions when that used to be done by the JAG? Why would the minister do that and not the Judge Advocate General?
That's a good question for the JAG, if I could.
Okay, we'll get back to it.
Okay.
I'll make sure we circle back on that one.
Thank you.
Was the Privacy Commissioner at all consulted on Bill C11?
You know,
Because I'm just thinking about.
don't think
you
so,
know,
but
the Victims' Bill of Rights, and when people are referred into the
I
civil
don't
system.
think so. I'm
you
looking
know,
down the
they're
table. I don't think so.
Victims' rights.
But that might be a very good witness to
Okay.
call.
Which provincial municipal police forces have you consulted on whether or not they have the capacity to handle the increase coming from the CAF when we
Yeah.
are referring?
My predecessor minister dealt with a number of police forces and a number of solicitor generals and a number of,
As to who?
I'm sure we can
Howdy.
get that for you.
James, that's it. Thank you, Minister. James?
Thank you.
Vivian Lapointe, you have up to 6 minutes.
Minister, members of the Canadian Armed Forces dedicate their lives to serve in our country, and they deserve a system that protects them with the same integrity that they show in uniform. Can you tell this committee how Bill C11 helps to rebuild the trust and the confidence amongst Canadian Armed Forces members who may have lost faith in the institution's ability to hold offenders accountable?
We're on a journey of reinvigorating the Canadian Armed Forces collectively as a people. This is a very meaningful step forward towards advancing a culture of respect and accountability across the defense team. This is about a suite of targeted amendments to help bolster confidence in our system and in the military justice system. And these amendments build on a succession of independent and external reviews that have been conducted. What it also really does is give implementation to Justice Arbour and Justice Fish's recommendations that are legislative in nature. So as I said, recommendation 5 of the Arbour Commission and 8 separate recommendations from Mr. Justice Fish. It basically removes the military jurisdiction over criminal code sexual offences committed in Canada. This is a big decision, but it's a very important decision, and it's the right decision. Because it is very, very important the Canadian Armed Forces not be in a situation where its members, its new recruits, its applicants, people thinking of careers, don't trust the system. And so what we're doing here is we're going to continue to address the needs of those who've been affected by conduct or by harassment or crimes of a sexual nature. So as I said last week in a speech on Friday in Toronto, so we can expunge this behavior and move forward and build a highly performing, more than it already is, Canadian Armed Forces.
Thank you. You touched upon this in your response, but I'd like to expand, for you to expand upon it because this legislation gives legal force to a key recommendation that came from Justice Arbour, ensuring that criminal code sexual offences are handled exclusively by civilian authorities. Could you speak to how formalizing this shift in law will strengthen confidence in the process for survivors, and what additional steps will follow to fully implement this change across the forces?
That's a very big question, an excellent question. It is, look, as a result of this legislation, the investigation and prosecution of criminal code sexual offences will now fall, as you say, under the exclusive jurisdiction of the civilian justice system. This was a strong finding of Madam Justice Arbour's review and her commission. This was very much about indicating to victims, to complainants, to people who are working or serving right now in the forces or in D&D, or those who are thinking of joining, that we're going to improve the architecture. We're going to make profound systemic changes. And there have been a whole series of these, which I'd like, we'll take more time to chat about when we have more questions. But this is very much, this recommendation is very much the cornerstone of Bill C-11. And we are convinced that it will have a major impact on building trust. Trust is fundamental to be able to recruit and to retain good people. And this is why this is part of our larger culture evolution efforts. And so there have been many, many other changes made systemically across the system.
Minister, this legislation has a lot. I think you said it addresses 8 recommendations. Can you outline or provide some examples of how this legislation directly advances the work that helps the government stay on track to complete the remaining recommendations by next year?
The good news is, before my arrival, a succession of team members, some of whom are sitting at this table, previous ministers, previous committees have worked together to facilitate many changes inside the system. What I found is reviewing all of re-examining the reviews that have come before. Each has built on the other. Each has led to systemic changes and systemic improvements. And this is why this is sort of not the crown jewel, but the last big piece we've got to get done legislatively. We're well on the way to, I think we've already, if I recall, we have implemented some 114 of 194, I think it is, total recommendations, if I have that number right, between those 4 fundamental reviews. In fact, with my experience in government, I haven't seen this before. I haven't seen a department organization take that many recommendations and actually operationalize them as quickly as they have.
30 seconds. Big question for 30 seconds, but can you talk about our commitment to institutionalizing culture change and how this legislation ties into that commitment that we've made?
It really did start from the top down and the bottom up at the same time. We had incredibly inspirational victims come forward and explain the impacts of this on their lives, which is beyond heart-wrenching, was very clearly unacceptable. That has led to an understanding that there was a fundamental challenge. This began years ago. These reviews were conducted years ago. And now we really want to move forward. That's why we devised, for example, a comprehensive implementation plan for all of these recommendations. Not randomly, but over a 5-year period, 23 to 28, looking at prioritizing and addressing all these 194 external recommendations. So none of them are left on their own. They're not stragglers. We fully intend to have these recommendations implemented by December of this year.
Thank you, Minister. Monsieur Savard-Tremblay, you have 6 minutes.
Merci, Monsieur le Président. Bonjour, Monsieur le Ministre.
Thank you, Mr. Chair. Welcome, Minister, and welcome to the team from the department. Thank you for being here. This is a sensitive topic, although we are talking about a solution here, and it is on the right track. Let's discuss a few points specifically. In the former bill, if I'm not mistaken, it was quite similar. That was Bill C-66. A number of victims, a number of people had been met with pursuant to the Arbour report, said that they hadn't been consulted before the drafting of Bill C-66. Can you say that for C-11 that has been remedied? People have been spoken to? Based on my understanding of things, Mr. Savard-Tremblay, there have been a high level of consultations outside of the department. Madame Tremblay, the external, Madame Terrien, the external reviewer that I met for the third time last week, in fact, is continuing her work. She is responsible for pushing the government to implement these recommendations, and she continues to reflect on this. She's continuing to support us and provide advice. Her fifth report actually was published in June, and all of that was considered in developing C-11. It depends on the review. The military college review, for instance, that had to do with 1,500 people. So the effort underway through these 5 reviews is comprehensive. So it goes beyond what was done for C-66. It's been ongoing since C-66. The dialogue is ongoing. The groups, the stakeholders, the NGOs are all involved. It's continuing, yes. I understand why that you would want this, the director of military prosecutions, these appointments on recommendation from the minister, the judge advocate general, provost marshal general, etc. I understand why, because General Vance was saying, "Hey, I'm in charge of the process. I'm never going to be released." There was no independence because the boss himself had control, directly or indirectly, on the legal process. Now things have politicized. Okay, people are saying, all right, let's put that, let's have that be external. And Minister, I understand you weren't the minister at the time. This is not personal. And you weren't even in cabinet during those 9 years prior to your appointment here, I think in March, right? So for the first time, you are now in cabinet. But we know that since 2015, these stories have been ongoing, and there's been silence from your predecessor at Defense. So the idea is to have it less non-politicized. But insofar as there has been this secrecy or even buddy-buddy kind of relationships, how can we trust in this non-politicized process? I think the improvements under C-11 include changes where the Provost Marshal General, the Director of Military Prosecutions, and the Director of Defense Counsel Services this has to do with an issue of perception. And it has to do with the influence of the chain of command within the Canadian Armed Forces. That's precisely what we've heard from the victims and stakeholders that were affected by all of these matters. So it's not about interference or political interference. It has more to do with the idea of having appointments that are open, more transparent, more predictable. I'm convinced that through these changes, we'll be able to help minimize mainly the perception that these positions are directly controlled by those in the chain of command, the superiors in the chain of command. I understand that. You've wanted it to be not a self-regulated process. You can't both be judge and jury. That's clear. That's the case here and in many other areas. You say it will be more transparent. From what I gather of the legislation, the government, through the minister, that's how, I mean, what else can be done to make sure there is no interference? Is there anything else that makes it clear that, okay, there is an appointment, but that is not under the control of politicians? sorry, are you referring to the minister, the cabinet, or the prime minister, the governor general? Who are you referring to exactly? Let's say all of the above. There are many rules. There's a criminal code that covers politicians. There's the ethics code at the federal level. It's difficult for me to perceive a situation where a minister would want to take a risk like that, one of interfering in a matter of prosecution. How do you say that in French? Les poursuites, okay. Just to reiterate, the appointment process through cabinet will improve transparency.
We're going to the second round, but before we do, there's a raised hand in the Zoom chat. And I again have to request unanimous consent from the committee to allow intervention during the session.
I'm sorry, I couldn't hear what the chair's saying.
Ms. Hilda, I've just acknowledged that your raised hand is there, and I'm asking the committee for unanimous consent to enable you to speak, and we don't have it, unfortunately. So we're going to continue our second round, and it now goes over to...
With respect, Chair, I would like to use my own voice to ask for unanimous consent to ask questions about victims of abuse in the Canadian Armed Forces.
Okay, so Ms. Laurier, if you could just by all means request unanimous consent.
Chair.
You're not a... Yeah, do we have? No, the answer is no, and I apologize.
Chair,
you're not
I would like to ask questions related to victims of abuse in the Canadian Armed Forces. And
I appreciate that. And it's important that you do. Unfortunately, we have a committee underway, and we have our existing members that are part of this committee, of which you are not, unfortunately, and we must proceed because of time, and I don't want to take it away from the members. Mr. Kibble, up to you. You have 5 minutes.
Greatly appreciate that you spoke to the importance of the sensitivity, the need for collaboration on this bill. So thank you for that. Which provincial justice ministers have you spoken to about this bill?
Which ones have I spoken to personally?
Yes.
None. Not since my arrival a few months ago, but I know that my predecessor spoke to a number of them.
Okay.
I'm not sure if they're all in the same positions now, but it was wide consultation amongst the provinces. My understanding is the MOU we have with Ontario builds on a series of conversations with the Solicitor General there and the previous one, which led to this negotiation, anchoring it, and now other provinces are being asked to look at the MOU as a possible model to follow. But so far, thus far, no province has taken up that offer.
Thank you. More provincial ministers, police forces, or Crown attorneys or Crown Attorney associations consulted during the drafting of the bill?
My understanding is yes. Their feedback was solicited widely leading up to the drafting and the elements of the bill.
Thank you. And earlier you mentioned one MOU signed in Ontario. How many MOUs have you signed with civilian police forces regarding the exchange of information?
That wouldn't be something that we
CAF
would.
members.
That's a great question. It wouldn't be something that we would normally sign with the police of local jurisdiction. It's much more a question of prosecutorial capacity at the provincial level. The federal government would not necessarily enter into this kind of dialogue with local police forces.
Okay, so you mentioned the MOU you mentioned earlier.
With the province of Ontario.
With the province of Ontario.
Yeah.
Have you entered into MOUs with the other provinces as well?
No, I was mentioning the offer remains. It's been shopped around. People have been, provinces have been asked for their feedback. That dialogue continues. There have been interdepartmental deputy minister and FedProv tables and so on. That work continues.
Thank you. Has there been discussion on a need for extra funding or resources to achieve these changes, given the extra cases being given to civilian
It
police
is something
forces
that we have raised,
and
something that we have
investigative, yeah.
examined internally. It's not something that we've come to ground on. None of the provinces have necessarily come forward in this regard, but it is also important to remember that it is the provincial responsibility to actually administer justice in the country.
So is the federal government considering extra funding for those services? For
Not
the
at
extra
this point in time.
Okay. Have you looked at mechanisms used by our allies to administer justice on sexual misconduct?
My understanding is yes. There's been a widespread analysis of some of our partners, allies, what's worked, what hasn't worked. Certainly the United States. I suspect Australia, New Zealand, and others. But this is a very Canadian approach, derived from 3 or 4 foundational reviews, the last of which was conducted by Madam Justice Arbour.
Okay, you mentioned the United States. Was that considered something similar to their model in the developing of this bill, similar to NCIS in the United States?
I think it was, although I would say today I'm not sure what the model would be in the United States. There are a lot of changes going on, so we're not sure to what extent that would be helpful in informing our approach.
Thank you. And there's nothing in Bill C-11 to compel civilian police to communicate with the Canadian Armed Forces. How will you make this happen?
To compel them to communicate with the Canadian Armed Forces?
Yeah.
Well, once a matter is transferred into the hands of a civilian police force, it's now part of the administration of justice chain. It wouldn't be something that the Canadian Armed Forces would be dialoguing with on a regular basis. If there's evidence, investigation, material, if an information has to be sworn, it would be transferred over to the police force, and then it's over to them and their provincial crowns.
Thank you. The bill says military police cannot investigate, so securing evidence is part of investigating. Can you comment on how military police will walk this fine line between securing evidence and not investigating? And would you be open to amendments relating to this in Section 70.2?
Did you mean outside of Canada or inside of Canada?
Specifically inside of Canada.
Yeah. That's a more technical question. I would much rather leave to the JAG, the Judge Advocate General,
Okay.
to give you more details.
And same for outside Canada as well? Because there's two
Outside
factors.
Canada is a different story, and Madame Arbour was very clear about that in terms of how we would proceed. And until the situation comes to ground, our MPs, our internal investigative organization structure would pursue the matter and bring it back to Canada and would be dealt with again through the local court system.
Thank you. And there have been problems with military officials not providing disclosure to civilian lawyers in a timely fashion in the past. Would you support an amendment to C-11 to prevent this from happening?
Certainly would like to hear more about it, because if that would help make it more robust, we're open to hearing more.
Thank you. And military police will not have jurisdiction inside Canada to investigate the crimes listed in C-11, but will retain jurisdiction outside Canada. Why would that be, if you could explain a little bit?
Well, because under international public law rules, we can't easily apply extraterritorial law from Canada, for example, in a situation like Latvia. And so we have to build a system which respects the fact that we have members of the armed forces living and serving abroad, for example.
Thank you.
So
And
it's not an obvious thing.
Commissioned Worship, if I may, just a last quick
Yeah,
word.
you're over time.
Okay, thank you.
I apologize.
Thank you, Minister.
Thank
Chris
you.
Mallet, over to you. Yeah, 5 minutes.
Thank you, Chair.
You finished
Through
28?
you to the Minister and I guess the Deputy Minister. As we've heard, Bill C-66.
Il faudrait qu'il ouvre son micro parce qu'il n'y a pas d'interprétation.
Pardon?
Il est ouvert son micro.
On me dit inaudible. Je pense qu'il vient d'être ouvert, mais au début, il n'avait pas.
Ah, okay.
The microphone wasn't on initially, now it is.
Ah, all right. Okay.
Merci.
You want me to start over?
Yeah.
Okay. All right, take it from the top, as the speaker says. Through you, Mr. Chair, to Minister McGuinty and Deputy Minister Beck, I would think. Bill C-66, as we've heard, started us down this path, and this is why this committee is now looking at the enhancements. Can we just delineate what exactly those enhancements and improvements and sort of the organic changes to the original, and what are the significant items that you would say would be highlighted in C-11 as opposed to what was originally proposed in C-66?
Yeah. The bills are not that distinguishable because they were considered to be appropriate. The balance had widespread support. All parties supported C-66. But I'm very much open to, as we just heard from Mr. Kibble, open to suggestions for improvement from the committee. But it's a good, supported bill across Canadian society.
Okay. On another issue, then, some concerns have been expressed that victims will have to use civilian victim services when moving into the civilian realm for the prosecutions. Will the appointment of victim liaison officers material improve victim experience? And will the military support for victims or complainants in these cases travel into the civilian realm? Will they still have the same services, if you will, once the prosecution moves into the civilian realm?
Answer yes. The victim liaison officers who will be receiving additional resources, getting more training, contemplated under this, making sure we're building psychologically safe and inclusive workplaces, for example. Not only that, but we're also amending access to VLOs, as they're called, for third parties who represent victims. Maybe that somebody who's a victim says, I don't really want to come out of my place right now. I'd rather have a third party act for me to get the assistance I need. So they can absolutely play a role with respect to the prosecutions and the investigations in civil society. The other thing to keep in mind is that we have a very, very well-established sexual misconduct support and resource center inside the department now, which is very much helping to strengthen support for survivors of sexual misconduct. So that body, the SMSRC, also now offers independent legal assistance and in-house counsel at no cost. It's also a needed improvement to give people comfort and give them the support that they need.
Just further and hand in glove with that, what guarantees are there that complainants will have access to the same amount of resources, especially around, as we discussed, mental health services, trauma-related resources as currently in place?
The Canadian Armed Forces is investing significantly going forward in mental health services at all 36, I believe it is, of our medical clinics. This is something that we're seized with. It is part and parcel of the need to invest in our people, to make sure they have the supports that they need, a place to go to, counselors to speak to, mental health advocates and experts. So this is part of the improvement we're making with the new reinvestment in the Canadian Armed Forces.
Okay. And again, our armed forces, as you said earlier, need to have a 21st century workplace. How will this bill have an overall cultural change, impact on the cultural change inside the CAF and on recruitment? If has that been at all considered as well?
It has. I think the two perhaps most important words objective here through C11 is to enhance trust and enhance transparency. We need to make sure that our Canadian Armed Forces is fit for purpose for the 21st century and fit for purpose for the women and men of the forces. It's very important to deal, as I said again last Friday to 500 individuals in a speech, it is time for us to expunge this behavior out of the Canadian Armed Forces. We need a high-performing force. They're high-performing now, and they're going to be needed to be even more high-performing going forward. And you can't have that. You cannot have that if you have lingering trust problems in the system. You cannot have that if there isn't a pathway, a predictable, transparent pathway to deal with this kind of conduct, which is exactly what we're trying to address.
Thank you, Minister. Thank you, Mr. Millet. Monsieur Savard-Tremblay, you have 2.5 minutes.
Merci. Alors, on va
Thank
parler.
you. I have two questions regarding the 60-day transition clause, the 60 days to transfer files to the civilian side. Have you reflected on how to make sure there will be no delays or issues with respecting to protection of the victims? And another question you can answer at the same time. With respect to those 60 days and transferring the files to the civilian justice system, people have denounced the fear of reprisal in the system now, and that there have been some measures of reprisal against people. What is there to protect these members? Two excellent questions. I can't fully answer the first. The the Advocate General can answer the first one, if that's okay. I think we'll have some time with them after your appearance. I think that's if you can answer the second question at least, as to reprisals. Well, we'll have to see once this bill is passed, once the system is in place. We can't exactly predict what's to come, but if there are any recommendations from the committee to improve things or reduce the likelihood that there would be problems post-transfer, then we're open. We're all ears. Perfect. Well, we've taken note of it, and we'll see for the second part. Do I still have some time? Perhaps we haven't addressed this one aspect that is also interesting in the bill, the creation of the center, the support center. If I'm not mistaken, it's not something that's been discussed for a very long time, but it is an interesting service. How to guarantee that these services to victims are distinct from the military hierarchy? That reports, the deputy minister can remind, the deputy minister reminding me that that's something that falls within the deputy minister's purview, and Mr. Gravel is there, and he can certainly answer those questions. Look, go ahead. I think you'll be here in the second part. I mean, go ahead.
Donc, merci pour la question.
Thank you for the question. Indeed, given the change in Bill C-11, there's been no change to support that is provided by the Sexual Misconduct Support and Resource Center, whether it be in the judicial system, in the legal system, in the civilian side system. The same supports will be available to victims. So the center's independence, its stability remains. The same services will be available.
We are now over to Ms. Gallant. You have 5 minutes.
Worship is considered sovereign territory. So if an incident happens on board in international waters, where does it fall in terms of jurisdiction? Who investigates and who tries?
My understanding is that it would be the Canadian Armed Forces, military police who would investigate, collect information, and then make a decision about how to proceed.
In Canadian waters?
Same thing.
So foreign territory and Canadian waters, the same thing.
Sorry, forgive me. No, I think in Canadian waters that matter would necessarily be transferred.
So on board a Canadian warship that's Canadian territory, the military police would have jurisdiction in both cases.
So this bill changes the appointments of key authorities such as the Provost Marshal, Director of Military Prosecutions, and Director of Defense Counsel Services in order to deal with undue influence. But what actions are being taken to ensure there is no political pressure, regardless of chain of command, and that this undue influence is not simply shifted to another authority?
That's an excellent question. And if Ms. Gallant, you see a way to improve that or make that more robust, we'd be certainly prepared to entertain it. I would be hard-pressed to believe that a Minister of National Defense would want to insert themselves in a prosecution of this kind. It's a legal matter. It's highly risky. It's illegal. It's unethical. It's against the ethics rules. And it may be, depending on the nature of that kind of involvement, subject to the criminal code itself.
What steps are being taken to guarantee access to witnesses, evidence, et cetera, for civilian investigations?
Forgive me, I'm sorry?
What steps are being taken to guarantee access to witnesses, evidence, et cetera, for civilian investigators?
Well, it would be illegal for...
And that's on base, Minister.
Pardon me?
And that's on base.
Yes. My understanding is that with C-11, this is basically an assignment of that responsibility and authority to police of local jurisdiction. So if there were a problem, for example, in Petawawa, whatever the local police jurisdiction would be there would have access, virtually, I think, from looking at council, unfettered access to the evidence, the information, and all that documentation would have to be surrendered.
Given the backlogs in the civilian justice system, what measures are in place to ensure victims are not simply transferred from one unjust system of cover-ups to one plagued with backlogs and delays?
Yeah, I don't know if I would agree with your characterization of a system of cover-ups. This is extremely serious business. The question of whether or not the provinces would be in a position to handle these prosecutions, these investigations through their police forces and their prosecutions, is one that we have been dialoguing with the provinces with for years. The MOU from Ontario indicates that it doesn't seem to be a problem in the making. We need to work together on this to make sure that we have a high-performing Canadian Armed Forces. And in my dialogue with provincial premiers like, for example, the Premier of Alberta recently, I'm reminding them on a regular basis the important role that our military plays not only for their safety and security, but for their economy.
How many victims did your office hear from when drafting this bill?
Does anyone have that number? Hundreds? Hundreds of victims? We can get you that number.
Okay. Rural communities often have limited budgets or lack staff. It's my understanding C11 does not offer any funding to ameliorate this. Why not?
So, you're talking about investigative and prosecuting?
Correct.
No one's asked.
No one's asked.
And so it's an interesting reality. But remember, too, we have a constitution. You wouldn't be surprised if the federal government started inserting itself into public prosecutions or into prosecutions conducted by crowns that we may be criticized as meddling in different provincial affairs.
Do you think the bill adequately protects the privacy of the victim, either from media attention or harassment at work?
Yes, I do. I looked at that very carefully.
And what will the minister do for better security and other measures to reduce the sexual assaults, since really the transfer passes the buck to an external justice without addressing the internal issue? So the bill doesn't address the prevention of assaults.
There are many measures that are underway. Much change has been effected over the last several years. You're right to point out the need to make systemic changes in the system. The chief is, of course, not only just the CDS today, the chief of defense, but in a previous life was responsible for implementing most of those changes. She's best placed at this table to help you on that one.
Ms. Gallant, that was great. Okay. Thank you so much, Minister. I will give 5 minutes now to Mr. Tim Watron.
Thank you to the witnesses for being here. Thank you, Minister. I have a technical question. With respect to the military police investigations outside of the country, it is a change in culture for them, and I'd like to know whether they will be getting ongoing training for these kinds of investigations abroad and how they will then transfer those investigations back to Canada. The answer is yes. There will be professional development training and investments, and when you remove the responsibilities for these investigations from Canada, it means the military police are freed up to spend more time, have more expertise, and use more energy to focus on situations abroad. These are small numbers of circumstances that, at least from what I'm gathered over the last few years, small numbers. But again, the Judge Advocate General will be able to provide more details with respect to that. It's not only training. It might be professional experiences such as our medical surgery teams, trauma professionals also need training, and they need professional development to maintain that level when the time comes to use these skills in deployment. It would be fully open to the Provost Marshal General to make arrangements with police services on the civilian side to have those investigators there and to maintain their skills during these investigations. Thank you very much. Bill C-11 addresses the legislative side of Madame Arbour's recommendations. The Justice had 48 recommendations, actually. 30, and you deserve credit for this, have already been implemented, so 18 remain. And we're told that should happen by the end of 2025. I'd like to hear what you have to say about the 18 outstanding and which ones are your priorities over the next few months. Yes, Mr. Speaker, you're right. By the end of the year, this calendar year, we should have completely implemented all 48 recommendations. Out of 114, how many exactly, I cannot answer, but I will certainly get back to you as to the exact numbers. We are compiling these figures by the end of the year. Are there a couple, one or two, that are going to be a priority to your mind? Certainly, Arbor 5 is something that we're discussing here today. If legislation is passed, we could consider that Arbor is completed. Perfect. Members of the armed forces are anticipating these changes, certainly for the civilian system to be responsible for sex assault prosecution, specifically for women. Why is this a priority to have this bill passed so swiftly? It should be a priority for all political parties, for all members here around the committee in the House of Commons and all members of the Canadian Armed Forces. It's unacceptable to have a system where people go to work and fear for what might happen to them, or that there's no avenue for a solution before them. And that's precisely why we're pushing for the implementation of these changes as soon as possible. As I said, we're open to changes and recommendations to improve the bill. So much work has already been done in the system outside of the legislative changes that I find it encouraging. That said, we have no choice. We need Canadian forces that are serious, that are high-performing, and where people feel as though they can have confidence in the system. When I visit universities and colleges and I speak to young people who might be interested in joining, enlisting, often women, we have to be able to look them in the eye and say, hey, look, this is a system that is well managed, that is transparent, and if there were to be any problems, there are solutions. You will be protected. You can trust in the system. And further to that, another point is that we're calling on Canadians to support the Canadian Armed Forces fully. And this is something we're doing. We're investing in our Canadian Armed Forces. And Canadians want to know that the system is well managed, that these types of problems from the past have been resolved or being addressed within the Canadian Armed Forces.
Watch horn. I will now pass it over to Mr. Anderson. You have 5 minutes.
Thank you. Many victims don't report instances of sexual assault to protect themselves. What does this bill do to alleviate that?
We hope that the bill will add to the changes, Mr. Anderson, that have been made inside the department to give victims confidence that they can trust the system, they'll be protected, that there's a transparent pathway, and that it's serious.
With cases going to civilian courts, what safeguards would this bill have to ensure that media reporting on the situation does not present an opportunity to dismiss important evidence at trial?
I'm not sure if I foresee that in terms of the rollout of what might occur. I don't know if our JAG can give me 1 line or 2 lines on that.
So,
appreciate it.
Thank you.
I don't contemplate that. Frankly, it may be. I don't know. We'll see what happens with the transfer system. But remember also that Crowns and defense attorneys can ask for publication bans. It's a part of the criminal system.
Okay. C11 indicates that sexual offences will be transferred to civilian court. Will those offences be tried under criminal code and or service code of discipline?
My understanding is they'll be under the criminal code.
Under the criminal code, okay.
Just like any other Canadian who's got a case to bring, be investigated.
Okay, so there won't be any overlap then?
Nope.
Okay. Will all sexual offences be transferred to civilian court or just some?
All criminal code sexual offences will be transferred.
All criminal code?
All criminal code sexual offences.
Regardless of seriousness?
All criminal code sexual
Gotcha.
offences.
For cases not transferred, why not? Where's the cutoff? Oh, sorry, never mind. That was if you had answered a different way.
All right.
How will cases that are found to be not a criminal code offense be transferred back to the military so that investigation and discipline can still take place under the code of discipline?
If the matter is not adjudged to be a criminal code sexual offense, it will remain inside the military.
So it would never have been transferred over in the middle?
Not if it's not a criminal code sexual offense.
Okay. C11 transfers these cases to civilian justice system because of the failures of the military justice system. Are there plans to make changes to the military justice system to achieve the required standards and eliminate conflict of interest for these deployments
That's a really
overseas?
Very, very important question and a good one. And I'm very open to hearing more from you, particularly with your own background, to see how we can get that right, get that improved. We have the JAG here who manages the system. We've made some progress, but we're very open to recommendations.
Okay. Will those changes be effective in ensuring, never mind, if we can effectively make those changes for cases abroad, why can't those changes be made through the Canadian Forces justice system such that all prosecutions, investigations, etc., are conducted by the military justice system properly, whether in Canada or abroad?
Forgive me, I didn't catch the question.
If we can effectively make those changes for cases abroad, right now it goes to the military justice system, why can these changes not be made throughout the forces right now so that regardless of whether it's domestic or foreign, they can be heard by the military justice system? In other words, if justice is not good enough here in Canada through the military, why is it okay over there?
Oh, it's a question of, I think, of fundamentally of international public law. It's where you're situated, right? You can't necessarily just apply Canadian law extraterritorially. If you have a situation, again, for example, let's say theoretically there's
forgive me, but understand that that's not really the question. The question is if we are going to rely on the Canadian justice system abroad, why can we not make those changes domestically to make it work here as well?
Well, we would be relying on the military police abroad and the defense justice system abroad. And if there were an occurrence abroad, it would be investigated and brought to Canadian courts.
Okay. If we can effectively make those changes, what kind of cooperative communication regime will be set up to communicate between civilian police, military police, and the command structure of the CAF once an accused is turned over to civilian jurisdiction?
Started. These prosecutions began as far back as 2021. Many of them have already been into the civilian court system. And so there's a very well-established sharing of information and understanding through two qualified police forces.
Okay. For instance, there was an incident in my own hometown where the accused and accusers were both sent home on the same bus. And the reason was no communication from the civilians once it was turned over to the civilians. So I'm wondering, in a case where a serving member is still on base and accused, and there's no communication from the civilian police force, what structure, what is the commanding officer on that base supposed to do with the accused?
Again, a very specific but important question. I haven't given that much thought in terms of the mechanics of this. I'm not sure if anybody here at the table can add anything to that. Can you, quickly?
So the same protective mechanisms that are available in the military justice system under the Declaration of Victims' Rights are available to prosecutors, judges, actors in the civilian justice system. So there can be no communication orders made by civilian authorities within the system, but certainly within the military, as proper maintenance of good order and discipline within the military, there's the ability of commanding officers to direct that members not communicate with each other and to make work arrangements to ensure that they are not together. The challenge, as you identify it, is ensuring that there's an awareness on the part of the commanding officer of the situation.
Thank you.
Sorry, we're over quite a bit,
Okay.
and I am sensitive to time. Ms. Sherry Doronado, you have the last go, please.
And through you, I'd like to thank the witnesses for being here. This is a tough subject for me. Justice Arbour indicated in a press conference in May 2022 that, and I quote, criminal sexual offenses should be within the exclusive jurisdiction of the civilian criminal court. This was the case prior to 1998. Military justice rests on the need to enhance efficiency, discipline, and morale in the armed forces. No other rationale was advanced in 1998 to vest jurisdiction in the military system for sexual offences, which until then had been within the exclusive purview of the civilian court as murder today. The handling of sexual offences by military court in the past 20 years has done very little to improve efficiency, discipline, and morale. If anything, it has served to erode it. Therefore, I see no basis for the Canadian Armed Forces to retain any jurisdiction over sexual offences, and that jurisdiction should be vested exclusively with civilian authorities. Minister, when I hear and I review that statement, I think it's very simple. We don't investigate and prosecute ourselves. And I think to myself, how many victims have not come forward out of fear of reprisal? How many actually suffered in silence? And how many actually left the Canadian Armed Forces with that trauma and they still suffer today? Who may be watching today and saying, maybe finally I will get my shot at justice. As you know, I'm a family member. And I speak to families all the time, whether it be people who have family members serving or people who have family members considering joining. And when my kids first started out, it was always about the job, the dangers they put themselves into. But over the last couple of years, it's always about the culture. It's about the change of culture. If you had some time to speak to victims today, and their families, what would you say about what we're trying to do here with C11 and the importance?
I would say, based on what I've read and heard, the conversations I've had with victims, that I'm heartbroken, that it's taken decades to realize we have to do something fundamental and foundational in making changes. I would say that we've listened. I would say that we're making legal and regulatory and structural changes inside the Canadian Armed Forces to expunge this kind of behavior. I would say that they are heroes for putting up with this and for suffering in silence. I would encourage those who are listening who may want to come forward to come forward. That's why I opened my comments this morning with a toll-free 24/7 phone number for folks to call for any victims, potential victims, anybody who is hurting. I would say that it's a foolish armed forces that does not want to avail itself of all the talent it has by allowing a culture problem to fester. And what we're doing here is to ferret this out, and we are putting in place structures that will allow us to go forward. There's such talent, such dedication, such values in the Canadian Armed Forces, such good people. We need to make sure that we get rid of extremism and hateful conduct and ferret out applicants. And we've changed the rules around, for example, how we screen applicants. We've changed probationary periods because we want to make sure that we have the right people. We're investing for Canada. Canadians are asking us to improve the situation. They're sending us a lot of revenues, saying, please get this better. So I would say for those folks, particularly the women, a lot of women, men, women, who are quietly asking, why did this happen for so long? We're moving forward. We're building on your standing on your shoulders, and we thank you. We thank you so much for sticking with us and allowing us to make these changes.
And thank you, Minister. Thank you, Ms. Raminato.
Thank you.
In speaking with some of the victims this morning, in fact, one of them brought up the fact that there is a best practice that exists in the military that they suggest we adopt in the civilian side, and that's the pre-charge screening, a model by which they found useful in assessing the viability of their prosecution in terms of its success to move forward. And if it does proceed that way, they feel that all civilian cases should go through that screening process the military does now. Minister, thank you.